For as long as I'm in practice, I definitely will do public interest litigation.
We as lawyers have a responsibility when we see injustice in front of our eyes to do something about it. Strategic litigation essentially is where litigation is taken up for a strategic purpose in terms of the impact that it will have to the society at large. Either you want to challenge a certain law, or you want the court to make a decision in furtherance to a human rights cause. But at the same time, there is also the public dimension to it, where you want to use the case to start off advocacy and discussions about this thing, because sometimes there might not be political will of lawmakers to actually do something about it. But by starting the conversation, by starting the litigation, that can be the starting point of changes in terms of law, in terms of policy, and in terms of approach.
I don't think it's something that people who do this sort of litigation begrudge, because we know this is how it's like. When it happens, it happens. You can't control events. It's very nice to sit here and to theorize about, when we want to do public interest litigation, you must make sure that the factual matrix are perfect, you must have a good litigant, the facts must be good, blah, blah, blah. It doesn't happen like that. Sometimes things happen and you just have to start the litigation, or sometimes it's out of your control because your client might be sued or facing charges and all that, so you just have to do it.
Public interest litigation has always been linked with the state of the country. My political awakening was in 1998 during the Reformasi era. I realized that there's a lot of things that were not quite right in the country. I became this very angry young man. I wanted to basically express myself more outside just the confines of my friends. And I met Edmund Bond. Edmund also invited me to be a part of a team of lawyers, young lawyers, defending a group of people who were detained under the ISA. And it was my first exposure to the injustice that we have here in Malaysia on account of our laws.
In university, I really, really enjoyed criminal law and family law. So I was determined to be a criminal lawyer. But how I actually started public interest litigation was the sexual harassment case that happened in Penang. Because I was volunteering at WCC at that time, they had come to see us. We realized that there was this really excellent organization in Canada called LEAF, Legal Education and Action Fund, and that is an organization run for lawyers, by lawyers, to do public interest litigation on women's rights. That was the first time I heard of feminist lawyering, feminist perspectives on law. So that completely changed the way I looked at law, practice, argue. So it's very interesting.
Hidup bersih! Hidup bersih! Hidup bersih! Hidup bersih! Hidup bersih!
Bersih is a civil society organization pushing for electoral reforms. The demands by this civil society organization for electoral reforms have not been met with much enthusiasm by the government. The organizers decided to have another rally right in the heart of Kuala Lumpur. However, there were some incidents that happened which led to the police firing tear gas and water cannons into the crowd. Basically, quote-unquote, hell broke loose. The aftermath of that is the Bersih 3.0 civil suit, which was initiated by the government.
The court case was a lawsuit by government of Malaysia to try and claim damages against Bersih 2.0 steering committee for damage that had been caused to public property during the Bersih 2.0 rally. I think all of us thought that it was a ridiculous suit. And also it was meant to teach us a lesson in some ways. To me, quite a vengeful, vindictive act on the part of the government.
We must remember one thing: the right to peaceful assembly without arms is a fundamental liberty guaranteed by the Federal Constitution, as well as, of course, being a human right. Unfortunately, at that time, I think the state felt that this right can be curtailed or can be prevented from being exercised. They say that under the Peaceful Assembly Act, the organizers of an assembly have the responsibility to ensure certain things.
However, that idea of that responsibility extending to paying for costs and damages is not something that's actually found in the legislation itself.
It was fully litigated until the end. We managed to succeed. MCCHR, they have actually assisted us in covering the costs of litigation. The work of civil society organizations such as MCCHR in Malaysia have actually contributed to the blossoming of democracy and the furtherance of human rights in our country.
Actually, we had a meeting with the Bar Human Rights Committee. At that time, it was headed by Edmund Bond. As we were discussing, then Edmund was telling me, hey, I have this other case, pregnant woman got fired. That sounds interesting. But I told Edmund, I said, if I get involved in this case, I don't only want to do the research, I don't only want to do the writing, I want to argue.
The incidents happened New Year 2009 where I get job interview, trained relief teacher. Then I'm successful during the interview. The officer bagi short briefing pasal terms of contract. At the end of the briefing tu, the officer said that who's pregnant come forward. So saya ke depan. Then the officer said that kita terpaksa tarik lah surat tawaran tersebut. Kata kenapa pula kan? Dia kata pregnant woman cannot apply for this job. In my mind, dekat sekolah pun ada guru yang mengandung. Why we can't kan? It's clear cut it's a gender discrimination case.
I think the most challenging aspect was to get the judges to look at human rights as something that can be enforced, getting the buy-in from the judges that international law is actually legally binding. I think we were really super lucky. At the first instance, the High Court judge was female. Part of the SFC's argument was that, teaching was a very dangerous job. And I remember the judge put down her pen and looked at her. Have you ever been pregnant? Which is actually not a good question to ask, but because clearly she had been pregnant before and she had worked. The fact that the judge is female, was pregnant before, and worked, the three things really kind of just nailed it.
I won the case. Justice Zaleha Yusof stated that my job application retractment is a breach of constitution right.
But did you see how it was like with the judges, How did you feel when you hear how the judges were like treating your case? How did you feel?
Macam ni ke sistem kita kan? It's quite sprunced off.
Yeah, was it kind of eye-opener for you?
What can I say dari awal 2009 hingga habis 2018, I can imagine how much is the cost. Maybe million. Terus terang not financially capable to bear the legal cost. Tak sangka ada lawyer aktivis macam Hani boleh bantu. Saya bukan orang yang kaya nak lawan sistem kerajaan.
And the one thing that's still good law in Malaysia is that Noorfadilla's case actually brought in the definition of discrimination against women. And that is the CEDAW definition. So that is now part of our law.
I would like to think that I'm firm but fair. I hold certain things as unshakable principles and that my ethics cannot be questioned. I'd like to think that.
He really takes the time to listen to what the client has to say.
We can help others definitely. When they come to us, they are in a position of needing help.
Is the client worried about how the outcome of the case is going to be? What are the chances of the judge saying this or that? What would happen? So he takes the time to zero in and listen and then see what the best strategy would be after that.
So it's now part and parcel of my practice doing this public interest work. So I don't need to say, okay, I need to spend only X amount of time for public interest cases. It's all work to me.
To advance public interest litigation is very challenging. We don't, most of the time, we do not see a positive result in court. But nonetheless, I always hear Shah telling me from his experience, he said, although we do not win or we might not win, but we still have to do it. If we do it, we are actually advancing human rights, advancing public concern, voices of public concern. Slowly, court would adapt to this kind of theories, to the public voices, and we would be able to make a positive impact.
That has spurred me to actually look at law not just as subject, but as a means to do something meaningful in society as well.
If you're running a feminist law practice, it's basically client-centric law, and the process is as important as the end result. So the client is fully involved. We make them write up their history. We make them think about why this thing happened.
We talk a lot to the client and then we try to understand things from their perspective instead of just them telling us what they did and then us just applying the law towards their case. We take the time to understand them and then understand what they are really concerned about, and then we address those issues.
Also ask them what they want, which sounds really weird. That alone is actually quite a revelation to many women. And the other thing about the feminist practice is also about the firm, how I deal with the other lawyers here.
That was something that I completely did not think about. If there is some concerns, insecure or fearful, which I'm not sensitive enough to catch that, and I think that's a very important thing that she is able to catch and be able to address with the client directly.
And that's why I say we run a feminist practice. Client-centric process is very important. Not the process just between the lawyer and the client, but also among the lawyers here. I mean, everybody knows I'm the boss, but we're constantly discussing with each other. Everybody gets a chance to say, you're talking rubbish. But they say that to me too. So, but that's quite interesting because then we can have more young lawyers getting involved in public interest litigation. It makes your life so much more interesting and you learn so many new things. Not just the law, you learn new laws, you learn new ways of doing things, new way of arguing things, I think it basically is a love of the law. Because our law is actually interdisciplinary. So if you're just thinking law, it's not going to work. It's law to do with social sciences, to psychology, humans,